And the very first things that we'll talk about are the changes. And we'll ask as we review the changes, do the tweaks make them tougher or tighter? Because that's ultimately what we need to talk about. And as we move ahead, the very first thing we'll talk about, and Tiffany, here we're going to go fast as we talk about some of the seller's disclosures change. And give me the next one, if you would. These seller's disclosure is a document that's not unfamiliar to you, and I don't have to explain to you what it's for. So let's move ahead and look at what's on the very first page of that disclosure statement. The first thing that's been tightened up is what making no representation means. It's not a punt, okay? Way too many people were thinking this is, I don't really want to say, so I won't. But look at the way the language has changed. The new language is on the right. Specifically notice, no representation should not be selected if the owner simply wishes to not disclose. It doesn't waive liability if the owner is already aware or subsequently becomes aware of a problem in the area that that question asks about. Okay, so they have really tightened that up, and we should be talking with our sellers about just exactly what it means. It means I don't have the knowledge. I can't say, I don't know. For instance, if you have to move out somewhere quickly, a house you've only owned for a year, and you haven't changed the HVAC, and you haven't redone the roof, how much about that stuff do you actually know? Not much. If, on the other hand, you've lived there for 25 years and you don't really want to say that the power goes out all the time, you can't just punt and say no representation. You have to tell what you know. Let's move ahead. And the next thing that's on the front page is a discussion of your duties, or in this case, perhaps non-duties, as a licensee, as you talk with your seller about what to do and how to fill out the seller's representation. Again, the new language is in the right-hand column. You have to deliver to the purchaser this disclosure before a real estate contract is signed or as otherwise agreed in the contract. And again, the language remains that says the representations are solely those of the owner and not of the licensee. This is not as big a change to me as the last one was. Now, as we move ahead again, what we're going to talk about is some things that have changed. I refer to this section as roof gutters and a laundry list. And I get laundry lists from all the things that are included in number 7, right? All the things that are included in number 7 are foundation, slab, fireplaces, chimneys, wood stoves, floors, basement, windows, driveway. And I could go on, okay? I won't, because I'll trip over myself if I do. But there's a whole bunch of stuff listed here. But look now at the questions that used to be asked. We're looking at the old version of the form. There were three questions asked in A and B. The year that the roof was put on, during your ownership, do you know of roof problems? And then the approximate year the structure was built. What isn't asked about on the old form? Anything having anything to do with the laundry list, right? Nothing about all that stuff listed in 7 is asked about. The age of the roof, when the structure was built, and repairs to the roof. Now, let's move ahead and see what it looks like now, because there are now 4 questions asked. The first one, year the roof was put on, that's the same. Second one, any roof leaks, repairs, or modifications, that's the same. Third one, approximate year the structure was built, that's the same. What's changed? During your ownership, the last one, describe any structural repairs or modifications to the items identified in 7. Okay, look again at 7. Now, how many things do we have to represent and answer about that we didn't have to answer about before? And again, this goes into place June 1st. There is much more to be answered now than there once was. Okay? We will keep forging on ahead because we could spend all kinds of time. Items 15 to 28 are necessarily new because on the old form, there weren't 28 for the grammarians in the room, okay? It used to be 15 to 25. It's now 15 to 28. 18 before leaves out any mentions of right of first refusal. Any of you had to contend with those? I want to buy my neighbor's house. I give my neighbor $1,000 to essentially hold the seller's door open for me and say, if you get an offer, I get 24 hours to match it. That's a right of first refusal. We have to disclose these now. Rights of first refusal were not mentioned in the old version of the form. Now they are. Moving ahead. 20, problems caused by fire, smoke, or water. I honestly think this is an improvement. This rework of this item. Why? When it's just asked as fire, smoke, or water, what do you think of? Yeah, and if it wasn't water damage from putting out the fire, would you necessarily include it in your answer? Not the way that it was written to me. So now we've made that clearer. And now the disclosure says problems caused by fire, smoke, or water, including any structure from rising water, water intrusion, or otherwise. The spot on the ceiling is now in play, right? And we have to describe it. We could have argued that 20 didn't ask about it before. I don't think we can do that now. Okay, moving ahead. By the way, just as a brief aside, I am going quickly intentionally just because there's so much stuff here, but I absolutely hate conveying any idea that I'm shutting down any interaction, because interaction is so much more fun and generally so much more beneficial. And if I'm the only one talking in the room, generally that's grueling. Okay, don't like it that way if it works out that way. So at some point along the way, if you need to, raise your hand and let me know. Item 22 before said erosion or erosion control affecting the property. We've again beefed up our definition of what is encompassed by number 22. Erosion, erosion control structure, such as a bulkhead, a rock revetment. Does anybody know what that is? I don't.
No. What's a bulkhead?
A seawall, buried sandbags, any of that affecting the property. All of that, I imagine, falls under the heading of protecting a shoreline. Okay, because we're talking about erosion here. So all of that deals with a shoreline, right down to the approximate size. Okay, because some of that shoreline control is underwater and not immediately visible. Sometimes that's the case. Moving on. Flood hazards. Now, the rest of this, 23 to 28, all the new stuff, they've gone to town on the flood stuff. And I'll show you what I mean. Okay. Again, it used to end at 25. The old 23 says flood hazards, wetlands, or flood hazard designations. Similar, except flood zones is now included. Okay. Because it's possible that you're in a flood zone and have never flooded at all, right? Now you have to say that even if there hasn't been flooding or flood issues in the past. We have to talk about that on the seller's disclosure. Moving ahead to number 24, flood insurance. That's roughly where the old form ended in its conversation of talking about flood. Now, is the property currently insured through public or private flood insurance? So do you have some sort of national flood insurance program, which, if I'm not mistaken, doesn't exist anymore, or I don't think you can get it anymore, or a privately purchased insurance policy? If either of those are true, that I as a seller have covered, I got to tell it. I got to tell it. All right. So as we move ahead to number 25.
Someone had a question about.
All right, let's go back. I missed it. Blind.
Piers or something.
It's in the chat.
Question 20.
Okay, in terms of the structural piers themselves, I would tend to say that if they aren't erosion control and they're actually just boat dock material, okay, that's not encompassed by 24 to the extent they are part of a structure designed to prevent or control erosion, they are. Okay. It would be one way or the other. If it has anything to do with erosion control, I would want to include it on 24. Okay.
It says not for coastal property.
She was referring to on 20, not on the erosion one.
All right. Would you scroll me back to 20, please? I'm sorry. Yeah, this would be regardless of whether we're talking about a coastal property or an inland property. If there's been any kind of water issue at all, some properties here in the upstate, for instance, if plumbing in a slab has gone bad, I had this happen, so I'm speaking from experience, and the house gets replumbed. Where does it often get replumbed? Through the attic. Okay, if that plumbing gave way and caused a problem in the interior of the house, I've got to disclose it. Even if I fixed it, I got to disclose it. Okay, that's where we are with 20. It's not just waterfront properties that we're talking about when we talk about water intrusion.
Water intrusion just could be high water coming in with a flood. It's going to come in. It's going to intrude into the house.
Right.
So
For sure. For sure. So wherever we left off, I believe we'll go back to 25. Okay.
What's the regulation on if the property changes and they remapped everything for flood insurance requirements? How soon does that seller get notified? Do they have to be notified in writing within a certain period of time so that they're aware? Because we run into this situation where people say that, oh no, I mean, you could say on public records, you could see that it's in the flood zone, but yet the seller's saying, no, I'm not required to have flood insurance. So does that fall in a time period where they have so much time before they have to be notified that they have to have flood insurance?
So for the benefit of those listening, the question is, what about if I didn't used to be in a flood zone on the FEMA map and the FEMA map changes? Now what do I do? Okay. If the flood zone map changes, which is in theory possible, okay, it doesn't happen often. I mean, the likelihood is pretty small, okay, but it could happen. And if it does, being a lawyer and being a conservative sort, I would say that if I knew I was this close to it when I bought my house, that I would periodically check. Okay, that's what I would do. I have a lot on a lake that a corner of the lot is designated as a flood zone. I'm going to watch it. I'm going to watch it from time to time.
you're going to be safeguarded anyhow, because when you go to get homeowners insurance on the property,
They're going to know.
They'll know, let's say you need flood insurance.
And John is right when he interjects that, you know, the homeowners carriers are keeping up with this, and they are going to tell you, because they search our addresses. They know where their properties are insured. And if they see that now I have changed to being within a flood zone, they are going to talk to me, and they're going to say, guess what you get to do now? And they're going to say, in order to keep your homeowners in place, you got to go out and buy the flood policy, which isn't included with your standard homeowners and is way too expensive. Both of those things are true. It's not included in your standard homeowners, and it costs you just way, way too much. As we continue talking about flood stuff, and I'm sure that part of this was motivated by as much coastal property as exists in South Carolina, but we also have to say repairs made as a result of flood incidents for which we did not make a flood insurance claim. This is brand new. This didn't exist before. Somehow, somewhere, people got wise to the fact that the seller disclosure asked them to talk about flood insurance. I'll outsmart those people. I just won't make any claims. So now we have to say, if we have made flood repairs, whether or not those were covered by flood insurance, we have to disclose it. Okay. 27 is also new. 27 says, has federal flood disaster assistance been received during your ownership? So this would be a federally declared disaster area, for instance. Would that show up? If yes, what was the amount received and what was it for? So again, if hurricane impacts coastal areas in South Carolina, and there's a federally declared disaster area and federal relief funds made available as a result, what do we have to do? We now have to say so, okay? And one last item that wasn't included before, number 28, talks about whether the property has been assessed for a beach nourishment project. I looked that one up, okay? Because I'm thinking about burying crabs or something, but that's not it at all. It's actually adding sediment or extending beach is a beach nourishment project. Now, if we're talking about floods, why is that a logical question to ask? Where do you need beach nourishment? Where it's being washed away, right? So that's why this question, I have to assume, now exists. All right, as we continue to forge ahead, under section 7, rental and rental management, before it said, describe the lease terms and any problems, okay? Kind of wide open. Now, because of another change, there is some additional language added, describe the rental lease terms to include vacation rentals, which are all over our new forms now. That's Airbnb Verbo type of stuff. That may reasonably begin no later than 90 days after the buyer's deed is recorded. What's the magic of 90 days? Anybody know? When we get to the vacation rental addendum, which is one of our new forms, one of the things that they show you is that the Vacation Rental Occupancy Act, that's not its actual name, but there is an act, a statute in South Carolina for vacation rentals. It says when you buy a home that has been used as a vacation rental, the rentals that are in place for the 90 days following closing are protected.
So there's a difference between a regular rental and a vacation.
Yes, there is.
You have to honor the regular. rental.
We have to honor the vacation rental that are booked for 90 days following the recording of the deed, starting day 91. We have the option of saying, we're not in that business anymore. Okay, and that's a new thing, and there is new forms for it. And obviously the seller's disclosure was impacted by the vacation rental stuff that's been going on. I think we ought to look on that relatively favorably in South Carolina. People are coming here, and they're coming here to vacation and spend money, right? We are happy about that, aren't we?
Just not the city limits.
Got to give you that. All right, moving ahead. Just above the signature. This is a little bit current status of property or factors which may affect the closing. All the check boxes are the same. There is just one under the after that isn't displaying because of the fact that I think Tiffany loaded this, but right under the leased box, there is a vacation rental box now. Okay, so you have to disclose if there are vacation rental leases in place, now in a couple of different ways. So we have hustled through the seller's disclosure. Let's move ahead. Okay, what about this one? Okay, have any of you gotten a look at this one? Those of you who work with buyers, this has changed, and I think the jury's still out on whether or not we like the change or not, but it's here, it's with us. If you're working with buyers as we move ahead, here's the important language, okay? This is the change. The yellow is the new language in the form. In the event that compensation being offered to the broker from the transaction is greater than the above dollar amounts. In other words, what you have filled out in those two blanks that are showing as either a dollar amount or a percentage. If it's different, if it's greater, then we don't have to do anything. So if you had said 3% to your buyer and the listing says 3.5, what do you have to do? Zippo, nothing, okay? You're good. And what do you get to collect? 3.5. Okay, that's it. Yes.
This is really a good thing. This is really benefiting the hardworking realtors that are out there. Because one thing that a lot of realtors are doing is cheapening their services and offering take a lower commission. Now it gives the ability that if the commissions aren't there and they sign a buyer's agency agreement stating that they understand that 3% is it, and they go in and somebody's offering 2.5%, you can go in and simply say, you're liable for the other 0.5%.
Right.
And it's going to be hitting you in your closing costs. Or the wiser thing to do is ask the seller for closing costs, which the commissions are part of, which they can use 750, whatever the difference is between 2.5, 3, as a closing cost that's going to come to the buyer's agent, and they could ask for $1,000 more in other things.
Oh no.
But it's this is maybe really an excellent move to protect a hardworking real estate agent.
So let's examine a couple of things, because this is one of the most important things that we will talk about today. That beep was only my battery, so I'm the one in trouble, not you. So really, if the seller's offering more, we get it. If the seller's offering the same, we get it. If the seller is offering less, and this is where I don't necessarily like the language of the firm, I like what it's intending to do. I don't like how it's worded. Buyer agrees that the greater amount becomes the commission. What about the lesser amount? It's not really addressed directly here, is it? That's my complaint with the form. Broker will disclose any change to the brokerage fee above, including any and all bonuses offered in writing. Now, here's how SCR webinar explained what to do in the event of less than what's here. Number one, and this is an SCR explanation, offer, what is it, Form 120, that talks about adjusting the compensation that the listing broker is going to pay. Number two, making the buyer eat it. Okay. Number three is a nuance of number two that John mentioned is, okay, we'll make the buyer eat it, but we'll make the seller contribute back in the form of a concession of some kind to the extent we haven't already exhausted them. Okay. And then the other thing that SCR said is a pen and ink change that's initialed by you and your buyer here on the form. Okay. But again, to John's point, that would be giving way. That would be running potentially afoul of cheapening the services.
Right, and as a buyer's agent, who are you looking out for? The buyer.
Yep.
The buyer's agent. So you don't want them to pay it out of their pocket. You want to try to get it themselves.
I'm going to work as hard as I can to move as fast as I can, because if I have to do this from memory, we're all in trouble. Okay. So let's go ahead and move ahead on to the next one. The buyers. Yeah, go ahead.
Well, I had a question about that.
Yep. Let's go back one, please.
Okay, so we're recognizing this is a contract between the buyer and the listing agent. I mean, the buyer's agent.
Yes, correct.
So how are you going to enforce that as a closing attorney? In the past, we've always emailed the attorney, the paralegal, and said, these are this is our compensation.
Right.
In the MLS, right?
And that is a
And-
brilliant question, because I don't know that there is a solid answer to that question. Kevin, do you want to speak to that at all?
Well, it's going to be difficult for the attorney because this is a contract between you.
We never see it.
and your clients. So it puts us in a horrible position as a closing attorney, because we've got a buyer and seller who are under contract, who we're working for to close the transaction.
Yeah. And
now you have a disagreement with your client over a contract between you and your client. So that's we would help as best we could. That puts y'all in a really precarious position. If your client says, I'm not paying that, our contract, our representation is with the buyer and seller to close the contract. It's not to represent you or your client in a dispute over your contract. So we probably would not have an ability to help necessarily in that situation. Y'all would have to work that out.
Well, if you were asking the seller for closing costs, okay, and then that, the buyer says, wait a minute, I want all of that for my closing costs.
Yeah.
Regular closing costs, and you say, wait a minute, that's part of that is supposed to go towards making up the difference in my commission, then you guys are responsible for the accounting part of it.
That's
and
correct. It was
checks
part
and
of the
balances
commission, it's part of
of
what they
what-
agreed to pay.
Yeah,
It would be in-
and you're responsible for paying those bills, you know, if there's fire, you know, the repairs on the seller's part or whatever, and you send that check to that contractor, then really, like, how are you gonna?
Well, for the benefit of those watching, I mean, the bottom line of the question is, what do we do if there turns out to be some sort of disagreement with this? And by we, I mean closing attorneys, because we're in a tough spot. This is the contract between you and your buyer. It's not a transactional contract, which is where we get involved. Going to the last part of your question, well, what if we ask the seller to adjust the concessions? That's where I think we would want the addendum to be sufficiently clear to tell us, and for both buyer and seller to sign off on, there's now this much more in concessions that's designed to apply toward X.
So
Okay.
the easy way to do this is if your fire agency agreement says 3%, and they are offering, let's say in this example, that they're offering only to compensate you 2%, when you bring your offer, then get the compensation agreement out and put in there the difference and saying that I have an offer for you. I am asking on this compensation agreement that you pay me an additional 1%. And once we've agreed upon this, I'm going to present my offer. Now, in a multiple offer situation, that can be very hard and difficult from the listing standpoint. You may lose out on that contract because of that 1% that you asked for. So at that point, you ask your client, are you willing to pay it? The difference, according to our agreement, it says you're going to pay 3%. And so when you walk in that house, you tell them they're only offering 2%. They're not agreeing to the compensation of they're paying the additional 1%. Are you willing to do it?
Yep. There was
According
another
to the contract.
There was another question here. Are you good?
I think everything got sorted.
Okay, good. So let's again move ahead because I want to make sure we hit some things. The agreement to occupy prior to closing, and as we advance here, again, this is the instance where the out-of-town buyer arrived on Wednesday, originally planning to close on Wednesday. They got bumped to Friday. What do we do now? Well, the seller's already gone. Sure, move in. We'll leave the key under the mat. Yeah. Notice what this form is careful to do. The yellow language is the new language. This form is intended for an occupancy of 7 days or less. For longer, parties are advised to seek legal counsel. What in essence is SCR trying to do? Trying to avoid you guys look like you're writing a lease and advising on matters of landlord-tenant law. Don't do that. And I don't have to tell you that. You know that. Just don't do it. Now, it's not new language, but it's incredibly impactful what's in red here. Once the buyer is through the threshold of the front door and occupying the property, risk of loss is now on the buyer, even if closing hasn't happened. Move in Wednesday, closing's Friday, Thursday, HVAC goes kaput. Buyer's problem. Buyer's problem. Okay, let's move ahead. It is the buyer's problem. Again,
That's what they're contracting.
as that's how the form defaults, that who's ever in the house is the one with the problem. Okay, notice
Okay, so
that
they have to get tenant insurance for 3 days.
actually,
Yes.
one of the things that is negotiable and I think advisable is to determine where insurance is going to be, or if it's going to be required to occupy. If I'm a seller, I say yes to keep myself out of the crosshairs of any such fight. Okay. Notice that it used to have just a date. They've now added a time that the occupancy begins, which is a good idea because I don't want anybody showing up at 1:30 in the morning. Also, all references to rent or daily rate has been removed. It is an occupancy fee. Now, notice what defaults in number 3. Buyer will only receive keys and get permission after the occupancy has been paid. It's not after, it's before. It's all up front. Okay, let's move ahead. Utilities will be placed in the name of, and you get to choose as of the date of the occupancy. I would say that if you wanted to remain consistency, this should say buyer too, because if the buyer has the risk of loss, the buyer should be paying bills. Okay. Should the sale not actually close? Number 6, this occupancy agreement terminates by 6 p.m. on a given date. Okay. How many days after? Okay. After receiving notice that the deal is not going to close. Now that would be the worst case scenario, right? I moved in. I thought I was going to close on Friday. In reality, I am not closing at all. That's a situation we have to deal with. Moving ahead. The flip side is the seller hanging on a few days after closing. You can probably predict based on the prior form some of the things that I'm going to say. So without flipping yet, closing is Wednesday, seller's there through Friday, HVAC goes kaput on Thursday. Whose problem? Seller. Even though seller no longer owns the HVAC system, seller's problem. Let's now move ahead. And let's move ahead one more. And the other thing that I would like to point out here is number 2. You've seen loan programs, have you not, where the buyer has to sign off on the fact that they're occupying the property and occupying the property within a certain period of time? That's what number 2 is designed to cover. Buyer has informed their lender of the fact that the seller's hanging on a little while. Your buyer will be signing off on that if they use this addendum, okay?
What does it typically say, 30 days?
You know, it depends on the product. Some of them are very fast. And I closed on a couple this week that said 60 days. Okay. And frankly, I wouldn't use this form if we were up against 60 days. I wouldn't use it. I'd get a landlord tenant lawyer involved to give you a short-term lease if we were actually talking about 60 days post-closing. Okay. All right. Same thing. Any occupancy fee, not rent, occupancy fee has to be paid in advance. Moving ahead. Now the new forms. Are they good, bad, or indifferent? Do they cause problems or do they solve them? As we move, the first one will be this short-term rental addendum. As we move ahead, you'll see one thing that's very interesting about it, and that is that after it sets up who the buyer and seller is, as we look at the next one, you know what it actually does? It actually sets forth the entirety of the statute. The vacation rental statute is printed in the addendum. And then what you go to is asking questions and answering questions based on the Vacation Rental Act. So number 2, who's the property manager? Because oftentimes those short-term rentals have those. And are we keeping it? Are we not keeping it? Has the buyer gotten a list of all the current bookings? Or is the seller about to provide that? That's the question in front of you. The next one that we'll move to now is the one that says, I do or don't intend to keep on that same management company. The new buyer may want to do the management himself. And interestingly enough, the very last thing here, seller shall be responsible for providing the buyer with all codes, keys, fobs, remotes, all of the access information that is needed, or replacement cost if they don't actually have them. That's crazy, right? Move ahead. The personal property addendum. Yep, no problem.
What it doesn't mention is the money. If I'm buying a property, my seller, John Doe, has an Airbnb downtown Greenville.
Yep.
book for 90 days and we sell to Jimmy Williams and says we're gonna honor those 90 days, but he's collected that money up front. I see nowhere in here was to talk about the transference of that money or who retains that.
Deposits.
The money is not in here, and I would, very insightful question, want to make sure that it is addressed somewhere. Don't leave it to chance. Where I think I might put it is in 28 of the purchase contract, which is the catch-all, or to simply include another addendum that says rent allocation. You know, first 30 days, seller gets 100%. Second 30 days, we split it. Last 30 days, buyer gets it all. However you want,
Spell it out.
just somewhere clearly say so.
But shouldn't that be part of the closing? Because that fund does not transfer at closing. Good luck getting it,
Right.
right? I mean.
Yep.
Part of it.
And it sounds like something that probably should have been on this form.
Yeah.
Yes.
Okay, thank you.
Okay. No, absolutely. These are the reasons we get together and try to hash this stuff out, right?
And
Because all of us together go, wait a minute. Now, the next form, as we move ahead, is the one that actually made me scratch my head the most. Okay. What conveys with the real estate? I mean, I'm so old school that we defined real property in law school as land and everything permanently affixed to it. That's the law school definition of real property. Okay. We've gotten away from that a little bit. Okay. I hate to have to say it, but this form goes from A to Y. That is 25 items. And if, now, those of you representing buyers, I hate to have to say this out loud, but I would always have your buyer sign this and throw it in. Throw it against the wall, hope it sticks. If you're a buyer, what else would you do? I want it all in, right? So there are things here that make plenty of sense, some that probably make less sense. I am very curious to see how this form goes.
We've had a form like this in place. I created it like 15, 18 years ago, and a lot of people have recreated it. And it has helped with a lot of the questions and concerns that come up by having something like this in play. For instance, recently we had somebody take a doorbell off of a home that was attached to the home.
Yes.
And they took it.
That's addressed here.
Right. And this would address that where before it was not.
By the way, one of the things, notice between the 1 and the A, the items below include smart and traditional versions of those things. So it includes your Ring doorbell and it includes your regular ding dong doorbell. Okay, both are there and both are included in the sale. Okay.
Unless noted in the.
Well, again, I look at this and I go, I do a lot of head scratching with this one for some of the items in particular. For instance, notice E, including bulbs.
That's reasonable.
Existing bulbs.
That's absolutely reasonable. There have been so many people that just take every single light bulb out of the house. For real.
Bulbs are $20 a box.
No, right.
A fixture, not a fixture.
Yep.
I'm taking it with me.
I guess.
Garage door openers, I get, because even though the garage door opener is itself an item of personal property, you can't use the real property without it. So I get that. Some of these other things we could argue about. One of my favorites is coming up. Let's move ahead to the next one. L, in-ground outdoor trees and plants.
I can attest to this.
I've had
Plants?
several where they say they're taking certain plants.
My grandmother's rose bush, and I'm taking it with me.
Chinese maples.
I'm bringing my lilies back.
I assume an outbuilding will stay.
I had a
No.
$1.5 million.
Not a foundation.
I had $1.5 million Lake Kiwi house. Day of closing.
The shrubs
Closing at
disappear.
2. All the shrubs in the yard gone, pulled out. So,
Wow.
So obviously, the reason that this form got created is fights have arisen out of this stuff, right? Now, again, from a buyer's perspective, I'm telling you, throw this against the wall and see what sticks, right? As a buyer, throw it out there, because then you've sort of put the burden on the seller to respond in such a way that make them name what's in and out, okay? Sellers, on the other hand, will have ideas that are all over the board on what should and should not be included. Invisible fence is there, kind of makes sense. It's under the ground, right? TV wall mounts and brackets.
Oh, yeah. No, people take those.
You know, garage storage systems attached to the wall or the ceiling. Does that include that like pegboard with the stuff with a bunch of holes in it? It's attached to the walls. Electric or smart port car charger, that costs you an awful lot to put there. Okay.
James, what about bathroom mirrors? The kind of mirrors that are just hanging on the wall.
Mirrors are on here.
They are.
Mirrors attached.
And
All
Letter
bathroom
N.
mirrors.
Yeah,
All
I
bathroom
have a
wall
seller
mirrors.
take
You
one.
know what I'm talking about? You have some that just hang there and some are fixed.
Is
Yep.
it not a hanging painting though? That's an argument I've had.
Really, a
I
painting?
had my seller say that.
Consider the
But they
bathroom
still
mirrors
took it.
being hanging paintings.
Now, the
They had
non,
the
I feel like I have a little bit of an advantage in talking to realtors because I'm one of the few real estate lawyers who's had a real estate license in his life. And one of the things that I always told people is they never want what they never see.
So take it down.
So before you ever list it, get it gone. Get it gone. And that's a really practical, non-legal piece of advice. They can't want what they don't know is there.
I had.
If,
James, going back to N, because because we have this issue.
Yep.
There's a lot of bathrooms where their mirrors are hung like a picture.
Yeah.
yes, I've got one.
Now, this is saying mirrors attached to walls, but it says all bathrooms. Is that separate? Or is that
All
saying all
bathroom
bathrooms
wall
that are attached?
For safety's sake, I would read all as all.
All bathroom
Yep.
wall mirrors.
Yeah.
And I have no disagreement with what you're saying is, look, it's hung on a nail like every other picture in the house. That's what you're saying, right? And I absolutely agree. And then I read that and go, so again, as we're working through this addendum, if a buyer gives you this, you got to be really clear on what you're pushing back with.
So as
From a
we're
lister.
saying the seller,
Yep.
from a listing perspective, the seller's disclosure would circumvent this or precede this, right? Say, hot tub, bathroom mirrors do not convey.
Well,
Because the buyer.
Jennifer, turn on your volume, please.
there is a box for excluding things. There is one. And as a seller, you can either use that to say A, B, C, D, and E, you're out of luck. Or you can say not including items listed as exclusions in the seller's disclosure statement. You're going to have options. As a cantankerous guy, I might say, we're not using this one. We're putting together a contract. This is too much and it's too confusing. I'm not using this. We're actually doing what we used to do. And saying personal property that conveys with is, and specifically look at that. Okay. And what we have just done is we handle the new forms. Okay. What are the new forms? Okay. Occupancy before and after. All right. Okay. Fire agency is modified. Okay. Fire agency is modified. But the new ones are the vacation rental, right? And then this. And those are the two new ones. Except for saving from those are the new ones. Now, two, the box we were just talking about is how you get out of this, right? How do you actually get out of this? Two says these things don't convey. Here's what I potentially see as a pitfall of this one. Our list is A through Y, 25 things. Are we going to ask buyers and sellers to line out 13 of them and initial 13 of them? That's going to get cumbersome and confusing because we all know how we work on strikeouts and initials, right? They're confusing as to where they've actually landed. So if you find yourself in that situation where the buyer wants them all in and the seller wants them half out, create a list. Okay, create a list that you do agree on, because otherwise I think this gets horribly confusing. It becomes a lot of spilt milk. Yeah, just a plain open addendum. You could, and again, the more of them that get there, the more confusing it is. Now, interestingly enough, note the last line. Seller has to repair any damages if we say we're keeping something and we took it down. So the bathroom mirror that really needs to go with us. If we took it down and left the wall anchor holes there because it was a big heavy thing, got to put that back. So how much do you really want that mirror? Your seller has to decide, right? Yeah, call the drywall repair guy.
How does that come from? We all have had this before, where people taking down the pictures they had all over the house and they have nails. Not big nail hole, picture it. What is really, that right there saying it is damaged, it is.
Right.
So how do you do a pin nail?
You have somebody there for it with, but you just.
I don't know that, but I mean. But
No.
most people do that.
No. No.
But
Well,
just
I mean,
fill it out in the front.
if somebody says something, then you have to do it.
I think what you do is you just make a standard, okay, that you agree to. And that's anything that's larger than we'll fix.
I have started recently asking the buyer and seller, asking the buyer agent to ask the buyer. Yeah, I'm advising the sellers to remove the artwork, but leave the images or leave the nails. Is that okay with you?
That's why they're saying, no, I don't want my picture of that.
Right.
Yep.
And then you know what all happens when you mud it and you sand it and you paint it and that same thing. Right.
It's not a match.
Goodbye.
James, can you restate that? Because we could not hear
Yeah,
the
and
answer.
I think generally that's a good rule of thumb. John is just being realistic when he says, some people are just going to want to get us trouble on this. So how do we contract around it? Is there a way to contract around it? And what I would simply do, if we feel like we need a way to contract around it, would be to say, okay, here's what we're doing, and here's what we're not doing with respect to the things that were hung on walls. Okay. Now, somebody asked a question about exactly making those repairs, and it disappeared before I looked at it. Did anybody read it? See that?
He asked if you had to patch and paint it or just patch.
Yeah, the patch and paint thing has the risk that we just considered, and that is, you know, I loved my 1978 paint job, but I'll never match it, right? You know, it'll just never be matched. So my default is to leave the hangers there, okay, and let the buyer decide what they want to or not to do. Yeah.
So if you want, if they are specifically want it, either way, write it in your contract. Or when you go to the American section, you just do it.
Well, most people.
Yep. You move forward.
Okay.
Yep. Move
James,
ahead
can
one
you
more for
repeat
me,
what
and I'm
they
going to
said?
sort of summarize and wrap up here as best I can, because what I have learned, and I don't know how much time you spend talking to people in a context like this one, but an hour's the outside. Okay. They're dropping like flies. See? I'm picking on you. Please don't let me do that. I got you. Now, just a few things that aren't new, okay? A few things, notice of termination, release of earnest money, okay? Those all come up with at least a decent amount of regularity. And the question that sometimes arises is, are these the same thing? They are not. They are distinct and separate, okay? So if a notice of termination is delivered by a buyer and I don't have a release as the closing attorney, I can't pull the termination fee out of the earnest money deposit. They're separate, okay? So it's the burden is on the buyer to provide that notice of termination, okay? And again, because I'm trying to hurry, the release of the earnest money is clear instructions for us at Guest and Brady. Where's it going? Who's getting it? Are they splitting it? Where is it going? That's just what we're doing, okay? And this is just one example of what that looks like. Now, what I would point your attention to here is option 4, because we do something at Guest and Brady that not everybody is aware of. A lot of agents write a purchase agreement that says nothing about interpleader. So as we move ahead here and look at it, let's do this. One more, please. No, it's right here. It's actually right here. This is the sales contract, second paragraph of item 5 that says, hey, if we have to fight over where the earnest money goes, that we are going to deposit it with a court to sort out your arguments, and that we're going to ask for a fee to be paid out of the earnest money we're fighting over to file that interpleader, okay? So if on Guest and Brady contracts, that blank stays blank, you'll get the next document from us, okay? We have this and we throw it back at everyone who gives us a purchase agreement without paragraph 5 being filled out, okay? $200 is going to be paid out of the earnest money. Why $200? Well, the reason it's $200 is if we end up with a sufficiently large earnest money deposit that keeps us out of magistrate court, that's what it costs, okay? Now, I've heard some agents advise that's why they'll never write an offer with an earnest money deposit greater than $7,500, because right now $7,500 is the limit on magistrate court. Okay, so that's why that happens. Okay, moving ahead quickly so that we can wind up. The stuff we've encountered, the release cancels the contract. We've talked about that, and as we move ahead, I want to point out like 2 more contract provisions. That's not as good as I hoped it would be. Paragraph 3 of the contract says essentially this: the buyer has found out everything that they need to find out. Okay. Now, one of the reasons we highlight this is we often talk about solar panels, which are there on that bottom line. Okay. Solar panels are this monumental headache from a transactional perspective. I'm not talking about the virtue or non-virtue of solar panels themselves. I'm talking about transactionally. They are a headache. And so if the buyer sends a seller an offer, just assuming that the solar panels are just thrown in for good measure and hasn't bothered to do their homework, what does this say? This provision says that, oh, we've done our homework. We know everything we need to know. And then later, when they find out everything they really need to know and their financing is in place and due diligence is over, if they walk away because of solar panels, I would not be surprised at all if the seller said, well, you can walk away if you want to, but you were fully informed and you told us you were fully informed, so I'm keeping your deposit. Okay, so people miss that. They go straight to the next issue, which is filling out the property address, the county, and the TMS number, right? That's where they go. Right above that is where you find that language. Last thing before we leave. The transaction costs here. If no box is checked, these costs will be added to the seller. I recently had a very disgruntled seller come back at me and say, you can't charge me that. It's not on my side of the HUD, oh, yes, it is. No box was checked. Now, we all grumble, I think, and maybe rightly so, about HOA transfer fees, right? I do. This one was $2,500. No box was checked. Yes. No box was checked. The seller was made particularly angry by the fact that in the bylaws for the HOA, it says that the transfer fee is to be paid by the buyer. But that's not the law between the parties. The contract is the law between the parties. This is where listing agents occasionally step in it, in my opinion. Okay, when they miss advising their clients on that. Now, the last thing, we are not tax lawyers. Okay, when we start talking about taxes, we commit malpractice. But our sellers still need to know about the I-295, right? And if we're representing an out-of-state seller selling their South Carolina investment property, this comes into play. And I think the recommendation should probably be from listing agents. This is here. You need to talk to your accountant about this. You need to get input from your tax professional on whether and to what extent you might be on the hook for taxes, okay? They are always very tempted to call me. And I always tell them the same thing. I'm not your accountant. I can't tell you what your gain will be. You need to take up that conversation with your CPA, with your tax preparer, and tell me what number goes in the blank on the gain, okay? And when people aren't aware of that soon enough, what happens? Obviously, they get disgruntled when you start talking about holding 5% or 7% of their money. And so look like a genius to your sellers, get them this information out front that it is something they're going to have to contend with if they are out of state sellers. Okay, I have taken too much of your time. Thank you for your graciousness and your patience with me.
Thank you so much, James. We really appreciate you and guests and Brady coming today to present, and Jennifer sharing the information and her office meeting with us today. We've learned a lot, and I would love to invite and have them back again to do more pitfalls and questions from the audience on another segment. We appreciate your time today, and thank you all for attending the Zoom visit.